Okay, I believe we are ready to begin this second hearing. I'm Judge Thomas E. Malone. We also have on this panel Senior Judge Patrick McEnany and Senior Judge James Burgess. We are conducting this hearing by Zoom under our court rules, our special court rules that we have for the COVID-19. I'd like to thank the attorneys for your cooperation in participating with this hearing in this manner. I'll go ahead and briefly repeat the preliminary remarks I made earlier. I remind counsel that we have read your briefs, so we are familiar with the facts of the case and what the issues are. You might keep that in mind as you make your argument. As the presiding judge, I'll be the timekeeper. Each side is given 20 minutes in this case to make your argument. The appellant's attorney should let us know at the beginning of your argument if you wish to reserve any of your time for rebuttal. After your arguments this afternoon, your case will be deemed submitted for decision. And after that, the court will take the case under advisement and we will get a written decision out to you and your clients just as soon as we possibly can. So with that, I'll call the next case on the docket. It is from Johnson County. It is number 121912, entitled The State of Kansas versus Beth Janice Merrill. This is an interlocutory appeal by the state involving a dispute about whether the district court properly suppressed blood test results. And so who do we have here for the appellant?
Good afternoon, Your Honor. May it please the court. I'm Jacob Gonteski. I represent the plaintiff, the appellant in this case, the state of Kansas. I'd like to reserve 5 minutes for rebuttal if I could.
All right. And who do we have for the appellee?
Good afternoon, Your Honors. Tom Bath on behalf of Ms. Merrill.
All right, Mr. Gonteski, we will begin with you. As you say, you wish to reserve 5 minutes for rebuttal. You may begin whenever you're ready.
Thank you very much, Your Honor. This case is about whether a nurse can screen an individual by asking a handful of customary questions and taking vital signs when that individual is brought into a hospital by police to conduct a blood draw that is authorized by a warrant. Unlike the district court in this case, this court should find that such actions are absolutely reasonable and permissible pursuant to the search warrant and absolutely do not constitute flagrant disregard for the terms of that warrant, particularly when the state has agreed not to use any of those vital statistics or any of the responses that the defendant made to the nurse there in the hospital beyond the blood itself against the defendant in this criminal case. That's why the state is seeking to have the district court's suppression of this blood draw reversed. I'd like to talk briefly about the facts of this case, and then I'd like to tell you about a handful of reasons why this court should reverse. First off, just as a background on the case, of another driver on the road was driving crazy when she slammed her SUV into the back of a compact car that was carrying two elderly women in the middle of a November day in suburban Johnson County, Kansas. When officers arrived, fire and medical were already attending to those who had been injured in their cars that were totaled. And the officer on the scene that was wearing a body camera, Officer Shields, then approached the defendant in her car. She was still sitting in the driver's seat. Her airbag had deployed in her face. The officer began a conversation with Ms. Merrill. It was apparent from the outset that she was intoxicated. You can see so on the video. I encourage this court, if it hasn't already done so, to pull up Exhibit 12 when it has time and review Volume 12. And it is Exhibit B, which is all the camera angles of this. It's excruciating to watch hours of this because there's different body camera angles, different dash cams, and so on. But there are some snippets that I've highlighted within the state's brief that are worth watching. What you'll see is Beth Merrill behind the wheel, and she's preoccupied not with the victims that she smashed her car into or anything else. She's preoccupied with her dog that's in the kennel of her back seat of her car. And she wants to get the dog out of the back seat, even though there's lanes of traffic going by in both directions. It's the middle of the day on a weekday. And officers are just trying to corral everybody and trying to discern what happened in this crash. What car struck what car? There were 3 cars involved. Witnesses that were on the sidewalk were approaching officers trying to tell them what happened and so on. So officers got Beth Merrill out of the car. She kept asking for her dog. She was trying to get her dog out of the back seat. Officers tried to stop that. They asked her over a dozen times just for her driver's license. She wouldn't get it. Eventually, officers ended up conducting field sobriety testing on Ms. Merrill, which revealed from the outset that she was intoxicated. She was far too impaired to be driving a vehicle. And so they took her into custody. They arrested her for driving under the influence after field sobriety proved that demonstrated that she was incapable of safely driving. They took her back to the station. By now, about an hour had elapsed into the time from the crash. They arrived back at the station around noon. And then after Ms. Merrill refused a breath test, then officers started digging into her criminal history and revealed that she had been arrested for DUI at least twice before. And so they applied for a search warrant to obtain a sample of her blood to prove her intoxication. They applied for that search warrant. That search warrant was granted, and then they got her back in from a holding cell. If you watch the body camera of Officer Shields as he's applying for this warrant, which was all recorded, you'll hear Ms. Merrill in the background in a holding room pleading for her dog. Over 100 times she asked for her dog throughout this whole interaction. And Officer Shields is just trying to stay on task and trying to get this warrant done. He realizes time is of the essence. He then gets Ms. Merrill out of the holding room. They take her to a car and they then transport her and they tell her, we're going to Menorah Medical Center to conduct this blood draw. She then asks, who are you? And he says, well, I'm Officer Shields. I've been working with you since the scene of the crash. And then she remembers. They go to Menorah Medical Center. A handful of times, Ms. Merrill says, well, that's where I bought my horse. Menorah Medical Center is what she's referring to. These are the kinds of things that the officers are dealing with as they're taking her and transporting her to the hospital. They transport Ms. Merrill to the hospital with the warrant in hand that's been authorized. All they want is that blood sample. They're trying to wrap up this DUI investigation and arrest. And they're even trying to already reach out to other people to come pick up Ms. Merrill after they're done with the whole booking process. They're trying to figure out how to get her dog and her back to safety after she's released. They get to the hospital, and the woman that they first encounter when they walk in the hospital is working at the front desk and wants to gather some biographical information from Ms. Merrill, from the officers, before they conduct this procedure. And what the record reveals is that the nurse then asked a handful of background information questions, trying to ascertain what brought Ms. Merrill to the hospital that day. Officers never direct those nurses into any of that. They never tell them what to ask, what to do. They simply say, I've got this vial here. I've got this box that's part of the kit for a blood draw. I'm just here to get this blood draw. That's what they tell the nurses. But the nurses go through a procedure because that's what they do. They go through a procedure to inquire of her some background, what brought her there, if she was intoxicated, if she was on medication, if she has prescriptions, and so on. And the officers are waiting there. They're waiting for the blood to be drawn. And by about 1:25 or so, the blood finally gets drawn. And then they gather Ms. Merrill and her things and they leave. They go back to the station, and then she gets released within about a half hour or so. What happened here is that Ms. Merrill at the district court filed a number of motions. She filed a motion to suppress the defendant's statements that she made at the hospital because she had earlier at the hospital said, I want to talk to my attorney. And the state agreed. Her statements at the hospital will not be used by the state in its case in chief, because indeed she had asked for an attorney earlier on in the process. The defendant filed a motion to have the prosecutors disqualified. That motion was denied. She filed some constitutional motions about the charging statute and the language of the statute and how priors can be used to enhance and so on. Those motions were denied. But the one motion that had some staying power in this case was the motion to suppress the blood test. And the somewhat unique argument that was posited in this case was that when the nurses gathered that other medical screening information, they disregarded the specific confines of the warrant and they gathered information beyond the warrant. They gathered information that they weren't authorized to gather. And as Mr. Bath argued successfully at the district court, this gathering of additional information beyond the four corners of the warrant, he argued, had converted this specific warrant authorized seizure of information into a general search, which was impermissible And the remedy for such a general search when officers go on such a fishing expedition is to suppress everything that was gathered, including the information that was authorized by the warrant. And the state simply disagrees. The defendant cannot offer any binding authority or even persuasive authority for the proposition that this blood draw result should be suppressed. I'd like to talk about 4 to 5 main areas of this. I'd like to talk about how the appeal that the state has filed is a fairly narrow one, the question about the district court's opinion and the district court's ruling, because the district court's ruling was actually fairly narrow. Number 2, the state's right to appeal is narrow. It recognizes that, but it's satisfied in this case when the district court suppressed a 0.31 BAC in a DUI aggravated battery case. Thirdly, a nurse acts very reasonably in conducting medical screening, which is divorced from any request by law enforcement or any direction by law enforcement in advance of a blood draw that was authorized. That screening does not constitute flagrant disregard for the terms of the warrant. It actually complies with Kansas law to ensure that the defendant is safe and that her safety is protected when a blood draw is conducted. And a specific warrant for a blood draw is not converted into an impermissible search when that medically reasonable screening takes place. So just a framing portion on the narrowness of the district court's ruling. The defendant in her brief to this court expounds upon at length the underlying facts pertaining to the other motions that had been filed, the other motions that are not the subject of this appeal, motions regarding statements that Ms. Merrill made or her request for an attorney or the district attorneys who she was seeking to disqualify or the constitutionality of the statutes. Dozens of pages of the defendant's brief are spent on those topics, but only a handful of pages toward the end of her 50-page response are pertaining to this actual issue, because what the district court found, the narrow ruling the district court made here, was that it was Nurse Reffitt's actions that converted this warrant from a specific authorized conduct into a general search. It was Nurse Reffitt's actions, not the actions of the officers, not the disregard for her request for an attorney, not any of that was at issue for the district court in this specific ruling that's being appealed. In this specific ruling that's being appealed, the district court made it clear, and I quote, "Where this case turns, I think, as to whether or not the court is going to grant the defendant's motion to suppress blood test results is the activity that took place at the hospital involving Nurse Reffitt." That's in volume 7, page 23. The court then found that Reffitt was an agent of the state because she wouldn't have been drawing the blood but for the state seeking to apply for that warrant. Whether she's an agent of the state is really irrelevant here. But the ruling wasn't about the invocation of the right to an attorney or any of that. Going back to the district court's ruling, I quote, "The whole violation this court is finding is the whole interaction between Nurse Reffitt with regard to the questions about how much she had to drink, taking the blood pressure, the vital signs, all of those sorts of things that were taken outside of the scope of the blood draw." The error that the state is appealing here is the simple error the district court made when it concluded that gathering those vital signs and that medical screening information constituted flagrant disregard for the terms of the search warrant. That's the error that the state is appealing and that this court should reverse. That's all that's before this court. To affirm the district court is to affirm that medical professionals cannot screen an individual brought to them for a blood draw. They can't ask those questions. Realizing that some of the information that Ms. Merrill offered up to Nurse Reffitt is information that would be incriminating, the state already conceded it will not use any of her statements or any of the vital signs or any of that against her in this trial. So there isn't a problem with what was gathered by the medical officials, the medical professionals in this case. To do otherwise is to affirm that medical professionals would have to do an invasive, what they termed in their own words, an invasive procedure with essentially a blind eye to a patient's safety, and that simply cannot be the case. The preservation issue that's addressed in the state's reply brief, I'm happy to entertain any questions this court has on that, but I'll stand on the brief for that portion. But I will just simply highlight that suppressing a 0.31 BAC in any case related to DUI absolutely does cripple the state's prosecution. The blood alcohol or breath alcohol test is absolutely the best evidence of any intoxication in any DUI related case, especially one in which the defendant barely submits to much in the way of field sobriety testing. This court in published opinions has already stated that reversing that the suppression of a blood test or a breath test result in a DUI-related case is ripe for an interlocutory appeal by the state. So that's why we're here. But I'd like to focus the remaining portion of my argument on why it is that medical professionals act reasonably when they conduct this screening, and why it absolutely isn't flagrant disregard for any of the terms of the warrant. When directed by law enforcement officers, the statute in Kansas, KSA 8-1001E, states that when directed by law enforcement, a medical professional shall withdraw the sample and deliver it, quote, provided the collection does not jeopardize the person's life, cause serious injury to the person, or seriously impede the person's medical assessment, care, or treatment. These officers were not themselves medically authorized to withdraw blood. They weren't going to do it in the backseat of a car. They weren't going to do it in the middle of a 4-lane road. They weren't going to do it at a police station or in a jail cell. They took her to a medical center to conduct that blood draw, and they did so in perfect compliance with the statute. Nurse Reffitt talked about extensively.
Could you give me that statute again, please?
I'm sorry?
Could you give me the site for that statute again, please?
Yes, the statute is KSA 8-1001E. It's the portion that talks about how a blood draw is to be conducted.
And by the way, was this done in the ER?
It was.
All right, thank you.
Yep. And Nurse Reffitt testified at the suppression hearings that she screened Ms. Merrill the same way she screens everyone that comes before her. She confirmed that she did so for the patient's safety, for Ms. Merrill's safety. This is in volume 5, pages 7 through 14 or so of Ms. Reffitt's testimony. She testified she was not acting at the behest of the police when she asked specific questions. The police merely wanted that vial of blood. They didn't want the other information. One of the other officers that was there, standing at Ms. Merrill's side, Officer Tierink, also testified that he understood these questions made by medical professionals that were essentially offered to make sure that the person they were dealing with was medically clear. Officer Tierink, if you watch the body camera of Officer Shields, Officer Tierink is the one that stands at Ms. Merrill's side throughout the process, the one that Ms. Merrill repeatedly reaches out to hold his hand, tells him he has a nice hand to hold. She cracks jokes with him throughout the interaction. While in her brief, she does highlight the fact that she at one point did say no to the nurse when a nurse was asking questions. This was followed up with some laughter and some recognition by Ms. Merrill that she just wanted to get out of there and get everything done. The entire interaction is remarkably lighthearted and at ease for everybody in the room. You see that when you watch the video. But these nurses acted in a medically reasonable manner. Nurse Hargis was the second one who came in. She's the one that conducted the draw. She didn't ask those questions. She didn't do any of the screening. She just came in to actually conduct the procedure. She testified this is an invasive procedure in our hospital, and we cannot do it to simply anyone that walks in. We need to have a chart. We need to be able to put some procedural information in that chart. And that's why the screening was gathered. Volume 6 is where she testified. So these nurses acted in a medically reasonable manner under that statute and under their own descriptions of their own activity at a hospital. Furthermore, such screening is absolutely not flagrant disregard for the terms of the warrant. In Kansas and in all the federal circuits and most states, the severability doctrine of such analyses reveals that the exclusion of illegally seized evidence is appropriate, but admission of the evidence that was gathered pursuant to the warrant still flows. That's what you sever. You sever the illegally seized evidence and don't allow the state to use that, and you admit that which was rightfully seized or authorized under the search warrant. State v. Kleypas.
You used 15 minutes, by the way.
Thank you. I'll use just one more minute or so, and I'll reserve the rest of my portion for rebuttal. When general warrants, when an officer goes on a fishing expedition and just disregards the terms of the warrant, as the cases the state highlights in its brief show, that's when officers, for instance, one of the cases was where officers applied for and were denied a search warrant for evidence of cocaine distribution and possession in a case. And they then got a very narrow warrant for some marijuana possession. They then went in and executed that warrant and gathered everything, including everything pertaining to cocaine and the other topics they had been previously denied on. That did convert from specific to general, and that was impermissible because they flagrantly disregarded the warrant. All the other cases, including a couple of 10th Circuit cases, the state cites reveal the same thing. But when there's not a fishing expedition, but rather when officers are confined to the practical limitations of the conduct that they're pursuing, even when they gather things around the periphery that are not within the purview of the warrant, when they do so because of practical limitations or practical scenarios such as executing a DUI blood draw, they're not flagrantly disregarding the search warrant, and they didn't convert this into something that was so impermissible of a fishing expedition as to require blanket suppression of everything that flowed. With that, I'm happy to entertain any questions this court has, and I'll reserve the remainder of my time for rebuttal.
No questions apparently, so Mr. Bath, you can go ahead and proceed whenever you're ready.
Thank you, Your Honors. I'll invoke Paul Harvey and now tell you the rest of the story. The defense would probably argue this was an intentional abuse of a citizen's right, which is sort of interesting given the climate we have across the country today. The court might phrase it this way: if the police employ a strategy to intentionally not provide a citizen who's in custody their Miranda rights, then they must not stray from that dangerous path, or else they're going to suffer dire consequences. Factually, Ms. Merrill asked 4 separate times for a lawyer over a period of 2 or 3 hours, and every time was either ignored or worse, was run over by the police involved. And not just one officer, not 2 officers, but 3 officers involved. There are 9 separate.
Who says she would have gotten a lawyer then?
Pardon?
I mean, that might have cut off any subsequent statements that she made, but she wasn't entitled to a lawyer right at that second, was she?
She was entitled not to be questioned. 9 separate times, Judge Malone. 9 separate times in the course of 2 hours or 3 hours. All violations of Miranda.
Once the warrant is issued properly, having an attorney makes no difference, does it?
No,
the warrant to get the blood draw is set. They can draw the blood. You don't need an attorney.
And you don't need to ask any questions. You're correct, Judge Burgess. I couldn't agree with you more. They didn't need to do any of the violations of the citizens' rights that they did, but they used that.
How do you expect a medical professional to proceed if they don't know who their patient is and what kind of condition they're in?
There's no evidence in the record that this was a medical screening appropriately done. You look at that record. I put it in my brief. We've cited to it. Ms. Hargis took the blood and did it in 5 minutes and didn't ask any questions. Ms. Hargis did not testify that the questions that needed to be asked that was done by Refit were necessary for the blood screening. Please do not be distracted by the shiny object. That is not what happened here. I mean, you listen to Mr. Gunteski, maybe you say to yourself, how could this gone off the rails? How could that possibly have happened? And I'm suggesting to you, judges, that Judge Draghi looked at the totality. There were 7 separate violations of Miranda's by the police, mainly within the realm of executing the blood draw, and there were 2 additional in concert with the hospital staff. And I'm happy to jump to each one of them if we need to, but I don't think that the state disagrees with any of those. Although, I think if you look at the district court's position when this all started, the state put in their pleadings that Miss Merrill, there were 0 instances of her asking for an attorney anytime during this. This is how this started in these hearings. Then each officer got up and essentially was reckless or lied about my client asking for an attorney or them violating the Miranda. Not until I had to play the tape. So the point is that the court was given at the start a factual scenario by the state that there hadn't been any violations. And not until we had to pull out all the video evidence, painstakingly, I might add, did the state then retreat to a position is like, well, we're not going to offer any of these statements, so it's all good. My point is, the court looked at more than just what happened with the nurses. The court looked at the totality, and he said there was a flagrant violation of Miss Merrill's rights. Secondly, there was not a normal screening here. There's no evidence to support the state's argument that this was Miss Refit's questions were done in the normal course. Additionally, when Miss Refit is asking her questions about how much you had to drink, whether you had any prescription drugs, My client says, I don't want to answer those questions, and the police direct her to cooperate with Ms. Reffett. The state wants to argue in their pleading that they couldn't interfere with this medical screening. Not only did they interfere, but they interfered to the point of assisting Ms. Reffett in asking the questions. Then they took that information, put it in the police report so that Ms. Merrill would get charged, and put it in the probable cause affidavit so that the conditions of bond would be set. So I disagree.
I'm a little lost on the facts, so I apologize, but I thought that on this, I thought that the nurse testified directly that her screening was routine.
Not for a blood draw. Ms. Reffert testified. She got called to the stand and she said, I have no memory of this at all. All she knows is if somebody is admitted into the hospital, she comes and she asks questions, but she never once said this was pursuant, these are standard questions pursuant to a blood draw. The state never established why Ms. Merrill was admitted to the hospital or asked those questions. They want to argue that they're pursuant to policy and pursuant to a blood draw. But that's not true. The record doesn't support that. And in fact, Ms. Hargis, who testified at a different hearing, who drew the blood, said she doesn't know why any of those questions would be necessary. Let me get to my notes here on Hargis, Your Honors. So the point is, Ms. Merrill saw two different nursing persons. One was Reffett, who asked these questions. Ms. Merrill didn't want to answer and was told to answer. And then Hargis, in fact, she testified, Ms. Hargis, who took the blood, she could provide no information why the nurse practitioner Reffett would have seen Beth that night at all. So while the state, and Mr. Gonteski's done an admirable job, is trying to connect this process to the blood draw, there's no evidence to support the record. That's why the district judge took the action he did. I don't think I somehow put Judge Draghi in a trance and was able to just communicate to him and make him do what I wanted. He saw this evidence. He saw the officers. Frankly, the state's position was not supported by the record, and nor were their pleadings. The cops lied about Ms. Merrill asking for a lawyer. They 9 times asked her questions in violation of Miranda, and the judge decided on the whole of the evidence that there was a flagrant violation. That's really all I have, unless you have specific questions.
Is there any case that addresses the issue of conduct after the material sought by the search warrant, as opposed to conduct occurring during the time of the search? Because the court has other ways of dealing with witnesses who lie under oath and do things of that nature that don't necessarily reflect back on the validity of the original action.
If I understand what you're asking, Judge McEnany, is we have some conduct, one of the instances before they get the warrant. Then we have 7 of the instances is in the process of taking her to the hospital, getting the blood, and transporting her back. But I think your question is, well, some of those instances happened after they got the blood. Am I correct in what you're asking?
For example, apparently you place a fair amount of significance in them lying in court in their testimony at these suppression hearings. Does that really bear that's sanctionable conduct in some fashion, I'm sure, but does that really relate back to the validity of the blood draw itself?
Well, I think not to the, and I didn't challenge the warrant on the blood draw, but I think when you have officers come in who were sworn to give evidence in a case, and at a minimum were reckless, but at worst intentional, and not telling the district court the truth, I think the district court can take that in consideration, whether this was an accidental or a willful violation of a citizen's rights. Officer Tiernick testified under cross-examination that notwithstanding someone's in custody and they ask for an attorney, it is the police decide when you get to have an attorney, and they decide that when they give the Miranda warning. Otherwise, an individual in custody asking for attorney really makes the police know never mind. So I guess I'm trying to answer your question, Judge McEnany, is that I think it goes to the totality of what Judge Draghi thought was going on here and the mens rea, if you will, of the police officers and what they did to Miss Merrill. I have nothing further if there's no other questions.
Other questions. So Mr. Bath, thank you very much for your argument. And counsel, you have, I believe, 4 minutes for rebuttal.
Thank you very much, Judge Malone. With these 4 minutes, one piece I'd like to highlight is the officers did testify at length when they were asked about the statements about whether or not Ms. Merrill asked for an attorney and so on, and why they didn't Mirandize her sooner. And they talked about why not. And they talked about how that's the way they approach DUI cases. They don't Mirandize before they do field sobriety. They don't Mirandize before they ask for a breath test. They don't Mirandize when they're taking for a blood draw because they're not going to interrogate her. And that's why. There are a handful of instances where they asked questions when they got to the hospital. And then after the blood draw, they asked questions. Like I said, the state has already agreed not to use any of that. It recognized that that's not admissible. And so it's not seeking to use that. But these officers absolutely did not get up there with some design to railroad Ms. Merrill and a design to lie their way through. They all had body cameras on. The booking video was on in the booking room. Everything was documented. They knew as much. If they didn't review these hours of video before they testified mistakenly, then that's one case. But to repeatedly caption them as liars, the state rebuts.
I'm still very confused on this important part about whether the nurses' screening questions were routine or not. I thought that there was some testimony, direct testimony from the nurse herself and maybe even some police officers saying that it was.
There absolutely was testimony to that effect. You can go to, for Nurse Reffitt, the individual who asked some of those questions and conducted the blood pressure screening and so on, volume 5, she's the first witness that was called. And so her testimony is around pages 7 through 14 or so. She talks about how she approaches each individual that comes to her the same way, regardless of whether they came in by police or not, to find out what brought them in, their medical history, their prescriptions, if there was a crash, the mechanism of that crash, and so on. If they obtained injuries, she testified that intoxication of an individual appearing before her is a relevant thing that she asks about. And she does it with everybody that comes before her. She testified to that effect in volume 5 repeatedly. She talked about how she asks these questions to ensure the safety of the patient. Officer Teering testified, volume 6, pages 54 through 55, that he believed those questions by the nurse were simply a matter of due course for medical professionals. And the RN, Hargis, that actually drew the blood, talked about how this is an invasive procedure. We can't just do it on anybody that walks in. They have to have a record number so that procedural information could be charted. They drew that blood. I'd like to highlight for this court the fact that the pole star of the Fourth Amendment is reasonableness. Reasonableness of this search and reasonableness of what officers did here. This was not egregious. This was not flagrant disregard of a warrant. To hold otherwise would be to require officers to transport defendants like Ms. Merrill to the hospital and then withdraw their blood without any inquiry about their medical state or about any allergies or any background that could be pertinent to an invasive procedure like a blood draw. Certainly Mr. Bath would be crying foul if officers brought her there and they stuck a needle in her arm with nobody ever seeking to ask her a single question and to ensure her safety. The defendant spends about 43 pages of her brief essentially obfuscating with the other issues that the district court had addressed on other motions, recounting in detail all of those other motions before finally addressing this issue, the suppression of the blood test. The defendant then spends about 5 pages, pages 44 through 48 of her brief, finally addressing this issue, the specific issue the state appealed. She offers no authority for her position that everything should be suppressed. She offers a mere 2 citations to authority, circuit court opinions outside this circuit. One of them is a civil case about tax records that were obtained by a government official, and the other one was a criminal case. There's no authority for the proposition that all of this should be suppressed. She offers no authority because there is none. The state highlights at length several cases in which courts did find flagrant disregard for a warrant, and it shows how egregious the conduct is. This is nothing of the sort. nothing even in a remote ballpark.
Got about 1 minute.
Thank you, Judge Malone. This is precisely the behavior that police, defendants, and the courts should want from police: a methodical investigation, suppression of specific items that may have been gathered outside the warrant that's already been suppressed. It already won't be used. Her blood pressure or other information gathered by those professionals at the hospital, that's not going to be used. But courts and police and defendants should want officers to conduct themselves this way to ensure a patient's safety when an invasive procedure like a blood draw is being performed. This court should reverse the suppression of this blood draw result and should remand the case back for continued prosecution. These reasonable steps, like I said, to the extent that you have time available, I urge you to watch Volume 12, Exhibit B, just for a sampling of what officers were faced with these days. In this case, there was never any acrimony. There was never anger between these parties. There was a great deal of jovial laughter and just recognition that we would just want to get through this, that daytime DUIs are really the bad ones. And we want to get this blood draw done, and we want to get you back home or somewhere else. They repeatedly asked her, who can we call to come pick you up? They didn't intend to keep her. How are we going to get your dog back to you who's been taken to the shelter and so on? These were the types of practical considerations these officers were dealing with as they transported her to the hospital and back, merely seeking the blood. It's abundantly clear from the video and their testimony. They just wanted that vial of blood and wrap the case up. So that's why I asked this court to reverse under this unlimited review, de novo review for this question of law. I'm asking that you reverse the district court's suppression of this blood test result and remand the case back for further prosecution.
Okay, counsel, you both did an excellent job. Thank you very much for your briefs and your arguments. And with that, this hearing is adjourned.